Greetings, friends. Howard and I spoke with a very special guest. He is a U.S. leading ethics attorney, and we discussed the very exciting emerging topic of private capital, or PE and family office investments in U.S. law firms. We discussed the two primary vehicles, the MSO and the ABS. Are they ethical and are they legal? What are the rules? Do they comply with the ABA Rule 5.4? And so much more. Enjoy. So welcome everyone to the Future is Bright podcast. My name is Chris Batz and my co-host Howard Rosenberg. Howard and I are at the epicenter of law firm talent and strategic growth here in New York City and the UK. Howard is a partner and head of talent intelligence and acquisitions at Barretts and Brunel, and then I advise and facilitate corporate law firm mergers at Columbus Street. So today we have a very exciting guest, Mr. Lucian Pera, partner at Adams and Reese. Lucian, welcome to the podcast.
It's great to be with you guys.
Very exciting. So, I don't know if you need an introduction. You're just known as the ethics guy here in the United States, addressing critical topics around law firms getting potentially in trouble with private investment and the creativity that's going on with Arizona and Utah and others. We're going to dive into MSOs, ABSs, and we're going to lean on you for insights in some of the creative things or just really what could happen for law firms here.
Great.
Let's start out with just a basic question. So what is an MSO structure in the context of law firms? How is it being used to allow PE investment while complying to ethics rules?
Yeah, well, it's number one, it's great to be with you guys. I appreciate being asked. And I can't remember when I've been introduced before by saying I need no introduction, but in any event, I appreciate that. MSOs is the current term we're using to describe the situation where a law firm outsources many or all of the things it needs, the services it needs to practice law to a company, an entity that is not a law firm. It originated in, I think, as far as back as I understand it, in the medical field back maybe 30 or 40 years ago. It has rolled through medical, dental, veterinary. There's a similar kind of structure in the accounting field that has been out there. But that's the basic structure. And if you think of it as, from a lawyer point of view, you think of it as outsourcing. From an investor point of view, you think of it as a way for someone who's not a lawyer, who therefore can't own a law firm or a law practice, to somehow participate in the economics of a law practice. So that's the shortest version I can give you.
Yeah. And the simple question is this legal? Can law firms do this?
Yes, they can. Yes, it's legal. As an ethics lawyer, it'd be awfully embarrassing to be, in any sense, touting or flexing some illegal conduct for lawyers. But no, it's possible. Ironically, that's probably not the right word, but most lawyers still are not aware of this concept. They probably are aware of how medical practices, for example, have been bought up, rolled up, whatever. I used to have an internist who I went to for many years who his regular complaint was about how I forget what term he used, but the suits or whatever were destroying the practice of medicine and all this. And that's what we're talking about. We're talking about the non-lawyer owners of the back office of the practice. So anyway, that's where we are. It is legal. I will say quickly, this probably should get to this early. In my world, in the ethics world, the authority we have for saying it's legal or ethical typically are either the rules or ethics opinions. Few cases, there are some cases. Ethics opinions are about the thinnest gruel in terms of precedent there is, because it's a bunch of volunteer lawyers, typically with a bar association, sitting around a table answering hypothetical questions. Well, even on that thin gruel, there is very little in the way of ethics opinions or other authority, virtually none, that speaks specifically to an MSO. Interestingly, the most, I think, closest authority that covers the waterfront is a recent Texas opinion that talks about outsourcing, where a firm is said to be allowed to outsource pretty much all the things they need to practice law, but there are quick caveats about you can't share fees, you can't let them control your firm, all that sort of thing. So there's authority to support each of the little pieces of the MSO structure, but very little out there that blesses the whole affair.
It's worth mentioning, obviously, the hot topic is Rule 5.4 in the ABA code. So I know you mentioned Texas. So it's okay. Like it complies.
Yeah, I don't think there's any
5.4.
problem in Texas or in any other jurisdiction in the U.S. with this. And to be clear, Rule 5.4, as an ethics nerd, I know what Rule 5.4 is. People may or may not remember. That's the rule that bars non-lawyers from owning law firms. It bars fee sharing with non-lawyers. It bars a few other things in the neighborhood of that. And none of those prohibitions, if you structure an MSO arrangement correctly, are triggered or violated.
That's amazing. So should law firms consider pursuing, what risks are there for ethical and regulatory compliance if law firms have this crazy thought of creating an MSO structure and pursuing private equity transactions? I mean, again, this is actually an emerging thing. It's a very quiet thing that law firms can actually take in private equity investment.
I mean, I don't know that I usually talk about it as law firms taking in private equity investment in the sense that, that's a shorthand. I understand what you're saying. My view is pretty simple. It is a tool. It is not for everyone for a whole variety of reasons. You shouldn't pick your tool until you decide how you're going to do the job the tool is for, what the job is, what the purpose is. And there are many law firms that they would have no good reason to use an MSO structure. There are, however, some purposes it has been used for and increasingly is being used for that hasn't been used for in the past, which matters. And lawyers, I think, need to get a little more familiar with that. So, for example, using an MSO is, well, let me back up. You start from the premise, as far as I'm concerned, in a discussion like this with a law firm about, well, what's your goal? Why are we having this conversation? Is this management by In-Flight magazine where you just read about MSOs and you want to know what the latest, coolest thing is? Or instead, do you have a business plan where you need capital? For example, for technology, are you a construction law firm and you believe that you have the wherewithal, that you have the thought and maybe the expertise, maybe you know someone with the expertise to build the latest, greatest AI tool for construction law firm clients. Maybe it'll answer their questions in a way without a lawyer's involvement. Maybe it'll evaluate vendor contracts or something like that. That's great. But let's hear the idea first, and then further, the business plan. Does the business plan require that you do a multi-year investment of a very substantial amount that's typically beyond what your law firm would like to do? Because like most law firms in America, your law firm cleans out the till at the end of the year every year and gives all that money to the partners. It's hard sometimes for some firms to do investments over time. And so starting from that premise, there typically are reasons firms need money or need investments, imminent mergers and acquisitions of other firms or technology, or other reasons. But starting from that premise, then you can figure out, well, is an MSO the tool that's fit for the job or not? I mean, as a friend of ours, we were talking about earlier before we went on air, as he has said a number of times, if you need X amount of money, it might be just as easy to go to a bank to get the money. It might be just as easy to go to your Uncle Jim to get the money. But there might be a situation where the MSO is the better tool.
Lucian, I'm curious that as you've been practicing a fairly, a good length of time, what are you seeing in the marketplace about this activity that you're engaged with? I mean, if you go back 5-10 years, are you getting more requests from clients in this area? Because this is, from Chris and I's point of view, this is increasingly new territory, but I'm curious, how rapid this subject has is becoming in your core daily work. You
are not behind. On the one hand, I have the longest ago, farthest back in time I have seen one of these models was 2006, and I can tell you about that because it's kind of interesting. But more recent, I've seen them kind of periodically over time since then. The last 5 or 6 years, it's been with increasing frequency, and these days, I don't know what precisely triggered it. I have some hunches. In the last year or so, the pace has picked up dramatically. One thing that's clearly driven it is the interest of investors, people with money, and their mindset seems to be, we saw medical be an area for some investment. We saw accounting recently in the last, I'm not sure, 3 to 4 years, I'm not sure, be an area for investment. And now the sort of, what I've heard some say, sort of the next frontier, the last frontier, whatever, is law. And as soon as you think in those terms, you then think, well, they immediately think of two things. They think of ABSs and they think of MSOs. And we can talk about that. But that has taken off in the last 6 months. With more and more lawyers hearing about this, thinking about this, asking about this. So you're not behind the times. This is just, it's a rapidly growing level of interest. And, by the way, a rapidly increasing number of deals being actually talked about. It's not just interest.
Well, I think that's where Chris and I see kind of the market evolving, that there seems to be this wall of money that sees law as an asset class, right. And everyone wants some sort of piece of the legal marketplace. They don't know what that means and what that actually looks like, but there is that the money aspect is clearly out there in the marketplace.
Yeah, there's no question. I mean, I don't know how many, but in a given week, I field at least 3 to 4, maybe 5 to 6 a week calls with new, let me say 4 to 5 a week of new calls from money. Probably another 2 or so, maybe 3 from law firms or lawyers. But the money calls are from family offices, private equity, all kinds of big money agglomerations. Some of the names I've heard of, most of them I don't, because I don't have a history of working with private equity. But that's where the interest is coming from. And by the way, the range of experience of the folks, and this is probably indicative for your audience, the range of experience of folks who are obviously savvy investors varies very widely. So there's some who literally, they say, well, we've been tasked by our company to investigate this line of business, and we don't know much of anything. We got a list of people we're calling. You're on our list. Let's talk. And they want basic information. On the other end, there are people who have deals. They say, we got a term sheet we signed last week. We want some help. So it's widely varying.
And what's the immediate reaction when you say MSO to these kind of money people? Like, do they freak out, or they kind of have the anxiety level goes through the roof? Like, what happens?
Well, that's the two parts of that. One is most of them have some knowledge. Some of them have some experience in these other fields, in medical or accounting. So they, there's some of them who don't have either of those experiences, which immediately tells me a little something about their, not their sophistication, but their experience. Others may have some knowledge of those fields, but nothing about law. They've never heard of it in law, and so they're looking for that. The other thing, frankly, it's one of the, I know this is going to sound weird, but it's one of the reasons I actually enjoy working with the private equity people, is that I've never finished a 30-minute call with these people, much less an hour call, without them raising part of the question you just asked, namely, what's the risk? Where does it come from? How does it manifest? Walk me through the risk. And risk, in a way, most lawyers are not. Lawyers are worst case scenario people, but they don't think quite that way. Most of them, I can tell when I'm talking to a savvy lawyer because they ask that. They say, okay, I hear what you're saying about it being sort of, it's out there and it's not common, but it's not uncommon, and there are not many ethics opinions. So what's my risk? What happens to me? The lawyers will ask the question like that. The private equity people will say, okay, so how common is this? How accepted is this? What's the risk? How does this go wrong? How does it come up? And so we have a meaningful discussion about that. I find that reassuring because candidly, it's a hard risk to assess. One of them, they had a real deal. I mean, a deal that was, they had a law firm interested. They had, I don't know if they had a term sheet, but if they didn't, they were on the verge of a term sheet. It was a very, very real deal. And the lead guy at the private equity group basically we had several calls back to back. He was having issues with his investment committee, and he was having trouble kind of explaining to them the answer to the questions you're pointing to. And, others, and I don't know that they were, at the end of the day, they didn't seem to be problematic, but on the other hand, it's difficult to assess. Hell, I can't even point to, I don't know that I can get to half a dozen of these arrangements that are public enough to discuss. And yet,
Are these deals in the mid-market? Are they boutique kind of practices involving law firms? Are they kind of the AmLaw 50? I mean, is there any kind of, or personal? Yeah.
There certainly are ones in personal injury that exist. Absolutely. I mean, I've represented some folks who've done those of some size. There are, I'm not aware of any that are done in the AmLaw 50. I'm pretty sure there is, I don't know if they break the AmLaw 200, but there are at least a couple I'm aware of with law firms of, more than 75 for sure. And there's some larger ones than that are being contemplated right now. But there also are, I mean, bear in mind, some of these are mom and pop operations. I mean, it's been 5 or 6 years. I'm remembering an immigration lawyer in Texas who had a tech person who she worked very well with, who had designed for her an engine to allow her to sell as a do-it-yourself service the completion and filing or applications for certain visas, like 5 or 6 visas. Apparently that is, it's a kind of commodity kind of product. And literally what she designed was a service where you, at least in those days, I don't know if it's still up, but you would go to her website and you'd have I'm visualizing two big red buttons. I'm not sure if that's how she displayed it, but there was a DIY button for a certain price. You press that, you invoke all the technology. They even mailed it in for you. Okay. You press at the other button, it was DIY plus a lawyer. You press that button, you get the same service plus a consultation with a lawyer. Anyway, to do that, she had essentially an MSO structure because she, number one, wanted to reward the technology person, and number two, wanted to get money in to support that. So, but it was that's why I say it's sort of a mom and pop operation. It wasn't that she was sending all of her back end to that office. I think she kept most of the back office of her firm in her firm, but it's still an MSO.
Lucian, can I ask a question and ask your opinion? So in your opinion, does private capital present a threat or an opportunity to the long-term future of the legal profession?
I guess my view is more on the opportunity side. I'm used to hearing from a very vocal, very small minority of lawyers who paint it as a threat.
Sure.
I learned a number of years ago that if you portray the people we're talking about here, the money we're talking about, if you call them private equity, you can induce panic and fear in whatever audience you appear in America.
Barbarians.
Because private equity is evil. I think we all know that. Yeah. But I don't share that particular view. Although maybe I do in some parts of my life. It depends what part of my life they have affected, I suppose. Isn't private equity supposedly responsible for not allowing us to have two-sided mattresses anymore? Isn't that private equity? I think that's anyway. But that's a different discussion. But in any event, my view is that this is a part of a longer, larger trend in the law business, which is both a business and a profession, to bring economic reality into it. When I started practicing law, I was at a very old line, the only other firm I practiced with, a very old line Memphis firm called Armstrong Allen. Our oldest partner at the time was Walter Armstrong. His dad was president of the ABA. He was by that time in his late 70s, I think. He was, the establishment, period, full stop. He wrote an article, actually more than one, in the Tennessee Bar Journal about how, and this was in the 80s, maybe, the early late 80s, how the advent of lawyer advertising was the death knell of the profession. Okay, I've never felt that way. I mean, I'm a First Amendment absolutist, which kind of helps in my view there, but I just think you're ignoring the real world. You're not, having the business of law be subject, as it has been since the dawn of time, to normal economic forces and principles, I don't find troubling, not remotely. And so as a result, I also don't find troubling the idea that if somebody wants to find creative ways in compliance with the current rules in order to deploy money into the law business, that doesn't bother me. Anyway, so I'm not freaked out by private equity. And by the way, it's not all, is a family office private equity, by the way? Is, some, behemoth investment fund, like, I don't know that they're doing anything but Russell or somebody like that. If they set up a fund to invest in law firms, would that be private equity? I don't know, but it doesn't scare me. I'm sorry.
So can I put you on the spot? Like looking forward, living in the future. When's the revolution going to happen that makes the mental gymnastics of this thing go away, and we can actually live in the real world, all of us united? Is that ever going to happen?
We're in the midst of the revolution, and it is happening little bit by little bit. In the 1930s, a great, I think, German physicist, Max Planck, was asked about how the acceptance of quantum theory was progressing, and his response was that it was progressing one funeral at a time. My partner, who I mentioned, and I don't mean to be too morbid, but my partner that I mentioned, who was dead set against lawyer advertising, he's dead. I loved him, wonderful guy, but the truth is there are some viewpoints that change only very slowly in individuals, and they change generationally with the change in the profession. Nobody talks about anymore the idea that the law ought to be a profession and not a business. Nobody says that anymore. When I started practicing law, they used to say that all the time. I think most people understand it's both, for God's sakes, and that's not evil or bad. It's just who we are and what we do. So we're in the midst of the revolution right now. It's just very slow, and I think gradually the lawyers are gonna understand. And then let me back up a step. I'm sure both of you guys, everybody in the world, is a consumer of media, right? Whether it's news or entertainment or whatever. The business of media, think about how it has changed from the advent of the internet, mid-90s to today. There are no more record stores. Albums are only a thing of the present because they came back after complete death, right? Music is not sold in albums. The unit of sale is a song. And by the way, it's typically not sold anymore, right? It's whatever you want to call it, as a playlist, right? So is that a revolution? And by the way, the news media, is that a revolution? I think it is, but tell me when that happened. So that's what we're going through in the legal business right now. We're going through a slow motion revolution. It is changing everything about the business and practice of law. It's the biggest change. I have a little riff I do once in a while. It's the biggest change to the business and practice of law in 100 years. If you go back 100 years, all of the modern infrastructure of the law business was created out of whole cloth. Law firms, bar associations, statewide licensure, a bunch of institutions like that. Did I mention law schools? Law firms, none of that existed before, say, 125 years ago. None of it. Those were innovations. They're all breaking down or being reshaped. So the revolution is happening, but if you talk to a lawyer in practice in 1910 about when the revolution was going to happen, they would not been able to tell you about the mid 30s. They wouldn't have been able to tell you that. That's where we are today. So.
How about you guys? I'm hung up on double-sided mattresses. I mean, that's like going to keep me up at night.
I thought it was the tags of the mattresses that were like,
Thank God we got rid of those. I don't know if that was a thing. I don't know about you, Lucian, but I don't want to flip mattresses.
I actually would prefer.
Thank you, private equity, for making that not a case.
Okay, well, maybe you're a fan of private equity if they're the ones responsible for that.
We'll blame them for best and worst.
You were their audience. You're who they were playing to, apparently. So anyway,
this is true. So we can't talk about MSOs if we don't talk about ABSs.
Right.
And I know you have a unique perspective on this, Lucian, as it relates to Phoenix and Utah. And I'd love for you to distinguish the two and that veil that you've described to me before.
Yeah, if you're an investor, you see the world of the legal space and where you might be able to put money to make money down two big avenues. One is ABSs, which is non-lawyer owned law firms. That term stands for alternative business structures. It's borrowed from the British. They adopted them about 15 years ago. The other is MSO. The other big broad avenue is MSOs. The ABS path, if you just think of it as non-lawyer ownership, started in the U.S. in 1991. By the way, the ban on non-lawyer ownership and fee sharing, that was put in place about 100 years ago too. Just FYI. But anyway, but back to the present, or more or less, 91 sees DC adopt non-lawyer ownership. It's very restrictive. It stays very restrictive. The restriction is that you have to be an individual to do that investment, and you have to somehow contribute to participate in the work of the law firm. So you can't, if you're a litigation funder, you can't really use the funding entity to do that. So anyway, then came Arizona and Utah in 2020 and the beginning of 2021. Utah enacted what's called a sandbox, came from apparently fintech, the fintech sector, the idea being that if you had a law firm and you wanted relief from, exemption from certain of the rules, you could ask for that in the sandbox. And once you had permission to, play in the sandbox, you got that exemption, you had to report in, all that sort of thing. So you had had the possibility of exemptions to the ban on non-lawyer ownership, fee sharing, and other things. Okay. Then Arizona went whole hog on this. Arizona said, okay, number one, apart from ABSs, we're going to lift the ban on fee sharing. They repealed the rule. Any lawyer in Arizona, whether they're in a non-lawyer owned firm or not, can share fees with a non-lawyer, period, full stop. That's a big deal. Most people overlook it, but that's a big deal. But as to ABSs, they set up a program which is now sort of maybe the dominant way to think about this, which is if you're a non-lawyer, you want to own a law firm, you can do so on application to their court. You go through a serious screening process. You then get a license granted. You have to have it renewed every 2 years now. The people who are key in decision making in the firm have to be approved, background checked. Closest analogy or level of depth is what lawyers go through for a bar application. Other interesting requirement out there is not only do you have to have a license, you have to have a compliance lawyer. You have to have somebody who's designated and approved by on application to the court who's responsible for your legal ethics and ABS rule compliance. Only law firms in America that are required to have an ethics lawyer as a compliance lawyer sort of formally. So that's ABSs. There are a couple other places as recently as June 17th, Puerto Rico adopts non-lawyer ownership. Nobody fully understands the scope of that at the moment. They published a rule in Spanish. I've got a decent translation of it. My understanding is limited, but my understanding is up to 49%. It's purely financial. That's your only role. The non-lawyer, you have to report to, I think, the court on how much money the non-lawyer makes out of the firm or is paid out of the firm. It's not clear how the process will work, but there's not an obvious requirement as yet for a license. They might, it's conceivable to me that they have some rulemaking to do. They might set that up. It's not clear to me. But it's early days. It would go into effect January of 2026. There's a committee out working on rules, regulations, something. So and it was put in at the instigation of a number of big plaintiffs, personal injury firms that have domiciled themselves in Puerto Rico. So one can only, based on no inside knowledge, one can only assume, given what I just described, those firms are looking for something like litigation funding investment.
Interesting.
But that's what we know. And by the way, the reason those firms domiciled in Puerto Rico has to do with taxes.
Yeah, there's a lot of tax phase firms.
Yeah. So that's Puerto Rico. So that's the ABS structure. But otherwise, the only other places that you might be able to have a non-lawyer-owned law firm in the U.S., Utah is sort of constricting their sandbox, so less possible now. Indiana is setting up a sandbox, not clear what its parameters will be. Okay. Washington State is setting up apparently a sandbox as well. It sounds as if that will include some ability to do non-lawyer-owned law firms there. Again, okay. It's not clear to me anyway as yet what the scope of that will be, but that's the landscape at the moment.
And why would someone do an ABS versus an MSO?
It's a very good question. Number one, and we can come back to this, there's some restrictions on the ability of an ABS to operate outside of its own jurisdiction, and those are real restrictions, and we can talk about those. But I think the reason is that you want a law firm, and you want a law firm that you own, as opposed to simply having an arm's length relationship with. Whatever you may think of the nature of the arm's length relationship and how much control it gives you, there's a difference. And ownership, as they say, has its privileges, and Arizona grants those privileges to non-lawyers to own firms. And so if you're willing to pay the price, so to speak, of the regulation plus the limitations, it's worth it. But I think that's the key point, is really how much control do you want, I think.
Well, it's definitely an evolving, very, very exciting topic that we'll continue to be talking about on this podcast. And Lucian, I have a question for you. If you can finish this sentence for me, the future is bright because?
Well, in this arena, because lawyers are learning that they are in a business, that economics is part of what they do. Traditionally, lawyers have not been good at that. I think we're getting better. I don't think that's a bad thing. And I offer in support of that the idea, if you've ever had any interaction with the court system, ever, picture, if you will, and think of your favorite retailer, Starbucks, Amazon, Walmart, whoever it is, your favorite retailer. Assume for a moment that the court system was run by them, and it was run by them aiming at you as the litigant, as the customer. And picture, if you will, how different that would be.
Very.
And I think it would be different. That's the revolution after the one that Howard asked about that we're in the middle of, the revolution in the court system. But I think law firms are way more responsive to clients than they were 20 years ago.
Yeah.
I don't see that as bad. I think I see it as a function of lawyers and law firms being sort of more subject to economic forces than they were before. That's a very long answer, but that's my answer.
I love it. Lucian, how can people find you, contact you, follow you on social media?
The benefits of an unusual name are that you can just Google it and you'll get to me. So even if you misspell my first name, which many people I've known for decades do, but if you just Lucian Pera, Lucianpera, just Google that, you'll get to me. And, phone, email, whatever.
Splendid. Well, Lucian, it's been an honor and pleasure. Thank you so much for your time today.
Thanks for having me. It's great talking to you guys.
Fantastic discussion, Lucian. Thank you.
Thank you.